Hi, I'm Paul Ashcroft. I'm a pension solicitor at Wedlake Bow. Welcome to this podcast where today I'm going to talk about the latest Lloyd's case on GMP equalisation, and then I'm going to look at the impact of Hughes on PPF compensation. Just to mention that these slides will be made available on our website if anyone would like to see a copy of them after this podcast. The requirement to equalise GMPs stems from EU law and the case of Barber. This case clarifies that the principle of equal pay between men and women applies to pension schemes. As a result, this is now established law that pension schemes only need to equalise benefits after the date of the Barber judgment from 17th of May 1990. Then benefits must be levelled up to those enjoyed by the most favourable sex from that date up to the date that the scheme is amended to equalise benefits. And for any period after that, benefits can either be levelled up or down. GMPs naturally have unequal retirement ages as they are linked to the state pension age, which has historically been unequal. For a long time after Barber, there was uncertainty when it came to equalising GMPs. However, the first Lloyd's case in October 2018 provided longer-awaited clarification that 1. GMPs must be equalised, and 2. how to equalise GMPs. Then, 2 months later, in December 2018, a second Lloyd's judgment clarified certain aspects of how Method D2 applies. So this was useful if you have a scheme that intends to use conversion to replace all the scheme benefits in order to equalise GMPs. Otherwise, it has quite limited applicability. This brings us on to the latest instalment of the Lloyd saga. The main issue that the third hearing looks at are whether the transferring or the receiving scheme will have to pick up the GMP equalisation tab for past transfers. Counsel for Lloyd's Bank argued that liability should rest with the receiving scheme, but during the hearing, the judge seemed to find it hard to believe that the receiving scheme should be liable for the wrongdoing of another scheme. However, it remains to be seen whether these observations will be reflected in the final judgment. It is also likely to be a few months before we see a judgment, as the judge has requested a further 2-day hearing at the end of October. At this stage, we have the original Lloyd's judgment, and so it's my view that there's no reason why schemes should not equalise benefits that concern any future transfers, and indeed many schemes may have already done so. However, with respect to past transfers, it would probably be prudent for schemes to await the Lloyd's judgment before equalising benefits. Next, I'm going to look at the case of Hughes on the lawfulness of the PPF cap. If a scheme falls within the PPF on an employer insolvency, members receive compensation equal to 100% of their scheme pension if they have reached normal pension age. Whereas if they have not yet reached normal pension age, then members receive compensation equal to 90% of their scheme pension. Compensation is capped at an amount that's reviewed annually, and certain restrictions apply to pension increases as shown on the slide. As a result, this can mean that some members may receive less than 90% of their scheme pension if they have not yet reached normal pension age. This resulted in court proceedings that tested whether, as a matter of EU law, member states have to provide a minimum level of protection. In September 2018, the CJEU ruled in Hampshire that PPF compensation must be at least 50% of members' accrued scheme benefits. The PPF then started applying a one-off value test to implement Hampshire, as opposed to, for example, tracking benefits on a year-by-year basis. This brings us onto Hughes, And Hughes is an important case for a number of reasons. Firstly, the High Court held that compensation cap amounts to unlawful age discrimination. It was also held that the PPF's general approach of using a one-off calculation method, even if it meant that more than 50% is paid in some years and less in others, was approved, provided that overall the cumulative level of compensation paid does not fall below 50% of the value of scheme benefits over the pensioner's lifetime. However, the PPF must provide 50% of the actual value of the benefits and not 50% of the actuarially predicted value as the PPF had suggested in their method. On the other hand, the PPF's approach to paying the survivor half of the member's benefits was not approved, and that's largely because scheme-specific rules may allocate survivor benefits on a different basis. It was also important for any schemes in a PPF assessment period, as it was clarified that trustees must ensure that any sums paid to members do not exceed the compensation that would be payable by the PPF. It is perhaps unsurprising that the Department for Work and Pensions has applied for permission to appeal the lawfulness of the compensation cap, and that the PPF has also applied to appeal some of the methodology points. However, there are at least a couple of points from the Hughes judgment that may reassure the PPF. Firstly, the decision relates only to the lawfulness of the compensation cap, not the 90% limit. The court accepted that as PPF compensation is lower than scheme benefits, this helps to deter employers from just dumping scheme liabilities on the PPF. Secondly, the judge has suggested that the PPF may not in fact need to make major changes to its proposed method in order to give effect to the judgment. Meanwhile, the PPF will continue to apply the compensation cap and is seeking permission to delay any changes to how it calculates compensation until completion of the appeals process. Thank you very much for listening. If anyone has any questions on these cases, or if there are any cases that you would like to hear more about next time, please let me know by contacting me directly. Thank you.